Reading within Subpart E of the Truth in Lending Act out of the Code of Federal Regulations. I'm on Valuation Independence 1026.42. This section applies to any consumer credit transaction secured by the consumer's principal dwelling. For purposes of this section, covered person means a creditor with respect to a covered transaction or a person that provides settlement services as defined and implementing regulations in connection with a covered transaction. For purposes of this section, covered transaction means an extension of consumer credit that is or will be secured by the consumer's principal dwelling as defined. Valuation means an estimate of the value of the consumer's principal dwelling in written or electronic form other than one produced solely by an automated model or system. Roman numeral 4, valuation management functions means recruiting, selecting, or retaining a person to prepare a valuation. Roman numeral 2, contracting with or employing a person to prepare a valuation. Roman numeral 3, managing or overseeing the process of preparing a valuation, including by providing administrative services, such as receiving orders for and receiving evaluations, submitting a completed valuation to creditors and underwriters, collecting fees from creditors and underwriters for services provided in connection with the valuation, and compensating a person that prepares valuations or for reviewing or verifying the work of a person that prepares valuations. Letter C, valuation of consumer's principal dwelling. Number 1, coercion. In connection with a covered transaction, no covered person shall attempt to directly or indirectly cause the value assigned to the consumer's principal dwelling to be based on any factor other than the independent judgment of the person that prepares valuations, through coercion, extortion, inducement, bribery, or intimidation of, compensation, or instruction to, or collusion with a person that prepares valuations or performs valuation management functions. Examples of actions that violate this paragraph include seeking to influence a person that prepares a valuation to report a minimum or maximum value of the consumer's principal dwelling, withholding or threatening to withhold timely payment to a person that prepares a valuation or performs valuation management functions because the person does not value the consumer's property at or above the certain amount, implying to a person that prepares valuations that current or future retention of that person depends on the amount at which the person estimates the value of the consumer's principal dwelling, excluding a person that prepares a valuation from consideration for future engagement because the person reports a value for a consumer's principal dwelling that does not meet or exceed predetermined thresholds, and conditioning the compensation paid to a person that prepares valuation on consummation of the covered transaction. Mischaracterization of value. Number 2, Roman numeral 1, misrepresentation. In connection with the covered transaction, no person that prepares valuation shall materially misstate the value of a consumer's principal dwelling in a valuation. A misrepresentation is material for purposes of this paragraph and is likely to significantly affect the value assigned to the consumer's principal dwelling. A bona fide error shall not be a misrepresentation. Roman numeral 2, falsification or alteration. In connection with the covered transaction, no covered person shall falsify, and no covered person other than the person that prepares valuation shall materially alter a valuation. An alteration is material for purposes of this paragraph if it is likely to significantly affect the value assigned to the consumer's principal dwelling. Roman numeral 3, inducement or mischaracterization. In connection with a covered transaction, no covered person shall induce a person to violate paragraph C2I or 2 of this section. Number 3, permitted actions. Examples of actions that do not violate paragraphs C1 or C2 include asking a person that prepares a valuation to consider additional appropriate property information, including the information about comps, to make or support a valuation, or requesting that the person that prepares the valuation provide further detail, substantiation, or explanation of the person's conclusion about the value of property, principal dwelling, I should say. And number 3, asking a person that prepares a valuation to correct errors in the valuation. Roman numeral 4, obtaining multiple valuations for the consumer's principal dwelling to select the most reliable valuation. Roman numeral 6, taking action permitted to acquire by applicable federal or state statute, regulation, or agency guidance. And D, prohibition on conflicts of interest. 1I. In general, no person preparing a valuation or performing valuation management functions for a covered transaction may have a direct or indirect interest, financial or otherwise, in the property or transaction for which the valuation is or will be performed. Employees and affiliates of creditors, providers of multiple settlement services. In any covered transaction, no person violates paragraph D1I of the section based solely on the fact that the person is an employee of or affiliate of the creditor, or B, provides a settlement service in addition to preparing valuations or performing valuation management functions, or based solely on the fact that the person's affiliate performs another settlement service. Number 2, employees and affiliates of creditors with assets of more than $250 million or both of the past 2 calendar years. For any covered persons in which the creditor has assets of more than $250 million as of December 31st for both of the past 2 calendar years, a person subject to paragraphs D1I of this section who is employed by or affiliated with the creditor does not have to conflict in interest in violation of paragraph D1I of this section based on the person's employment or affiliate relationship with the creditor if the compensation of the person preparing the valuation or performing valuation management functions is not based on the value arrived at in any valuation, or 2, the person preparing a valuation or performing valuation management functions reports to a person who is not part of the creditor's loan production function as defined in paragraph D5(1) of this section, and whose compensation is not based on the closing of the transaction to which the valuation relies, and 3, no employee, officer, or director in the creditor's loan production function as defined in paragraph D5(1) of this section is directly or indirectly involved in selecting, retaining, recommending, or influencing the selection of a person to prepare a valuation or perform valuation management functions, or be included or excluded from a list of approved persons who prepare valuations or perform valuation management functions. 3, employees and affiliates of creditors with assets of $250 or less for either of the past 2 calendar years for any covered transaction in which the creditor has assets of $250 million or less as of December 31st for either of the past 2 calendar years. A person subject to paragraph D1I of the section who is employed by or affiliated with the creditor does not have a conflict of interest in violation of paragraph D1I of the section based on the person's employment or affiliate relationship with the creditor if the compensation of the person preparing the valuation or performing valuation management functions is not based on the value arrived at in any valuation, and the creditor requires that any employee, officer, or director of the creditor who orders, performs, or reviews valuation for a covered transaction abstain from participating in any decision to approve, not approve, or set the terms of that transaction. 4, providers of settlement services. For any covered transaction, a person who prepares valuation performs valuation management functions in accordance with, in addition to performing other settlement service for the transaction, or whose affiliate performs another settlement service for the transaction, does not have a conflict of interest in violation of paragraph D1I of this section as a result of the person or person's affiliate performing another settlement service for the transaction if the creditor had assets of more than $250 million as of December 31st for both of the past 2 calendar years and the conditions in paragraph D are met, or 2, the creditor had assets of $250 million or less as of December 31st for either of the past 2 calendar years and the conditions in paragraph D3 were met. definitions for purposes of this paragraph, and following definitions apply. 1. Loan production function. The term loan production function means an employee, officer, director, department, division, or other unit of a creditor with responsibility for generating covered transactions, approving covered transactions, or both. 2. Settlement service. The term settlement service has the same meaning as RESPA. Affiliate. The term affiliate has the same meaning as Reg Y of the Board of Directors of the Federal Reserve System. Letter E. The extension of credit prohibited. In connection with a covered transaction, a creditor that knows at or before consummation of a violation in paragraph C or D of this section in connection with the valuation shall not extend credit based on the valuation unless the creditor documents that it has acted with reasonable diligence to determine that the valuation does not materially misstate or misrepresent the value of the consumer's principal dwelling. For purposes of this paragraph, E, a valuation materially misstates or misrepresents the value of the consumer's principal dwelling if the valuation contains a misstatement or misrepresentation that affects the credit decision or the terms on which credit is extended. F. Customary and reasonable compensation. Requirement to provide customary and reasonable compensation to fee appraisers. In any covered transaction, the creditor and its agent shall compensate a fee appraiser for performing appraisal services at any rate that is customary and reasonable for comparable appraisal services performed in the geographic market of the property being appraised. For purposes of paragraph F of the section, agents of the creditor do not include any fee appraiser as defined in paragraph F4I of this section. 2. Presumption of compliance. A creditor and its agents shall be presumed to comply with paragraph F1 of the section if I, the creditor, or its agents compensate the fee appraiser in an amount that is reasonably related to recent rates paid for comparable appraisal services performed in the geographic market of the property being appraised. In determining this amount, the creditor or its agent shall review the factors below and make any adjustments to recent rates paid in the relevant geographic market necessary to ensure that the amount of compensation is reasonable. A. Type of property. B. The scope of work. C. The time in which the appraisal services are required to be performed. D. Fee appraiser qualifications. E. Fee appraiser experience and professional record. And F. Fee appraiser work quality. And Roman numeral 2. The creditor and its agents do not engage in any anti-competitive acts in violation of the state or federal law that affect the compensation paid to the fee appraisals, including entering into any contracts or negotiations in any conspiracies to restrain trade through methods such as price fixing or market allocation as prohibited under Section 1 of the Sherman Antitrust Act or any other relevant antitrust laws, or engaging in any acts of monopolization such as restricting any person from entering the relevant mortgage antitrust or causing any person to leave the relevant geographic market as prohibited under Section 2 of the Sherman Antitrust Act. Number 3, alternative presumption of compliance. A creditor and its agents shall be presumed to comply with paragraph F1 of the section if the creditor or its agents determine the amount of compensation paid to the appraiser by relying on information about rates that is based on objective third-party information, including the fee schedule, studies, and surveys prepared by independent third parties such as government agencies, academic institutions, and private research firms. I'm going to break here.